Hello, everyone. Thank you so much for joining us. So we're just going to get started. Oh, am I muted? Are you able to hear me? Gil and Leanne? Excellent. Okay.
I can, yeah.
Okay, so I just want to start by welcoming everybody to our webinar focused on Bill 32. Okay. So just going to go over some of the brief formats so far. So I'm just going to do the introductions, and then we're going to turn things over to Gil McGowan, president of AFL. And he's going to provide kind of an introduction to our topic today. And then we're going to go over to Leanne Chahley from Blair Chahley Lawyers, and she will give some of her analysis of the changes in the bill. And then Susan Cake, I am the Director of Policy Analysis for the Alberta Federation. I'll provide some impact about the practical impacts for workers about the bill. Then we will go over to a question and answer. So get your questions ready. Just some logistical things. So there's a comment section on the side where you can type things for the entire group to see. And when we take questions later, if people could use the question and answer function, that would be great. Find it by hovering your mouse over the bottom of the screen. And just, there is an option to ask questions anonymously if that's how you would like to go ahead with it. There will be a follow-up email sent, so if there's any links or documents that are shared, we'll make sure to include those in the follow-up email sent to everybody. Any resources, really. And with that, I'll pass it off to Gil to give us an introduction.
Okay, well, thanks, Susan and Leanne, and especially thank you to everyone who's joining us tonight for our discussion on Bill 32. And it's a question that many people in the labor movement and beyond are asking. What exactly is Bill 32? So we're hoping to answer that question tonight and explain to you why we in the Alberta labor movement are so concerned about this piece of legislation. So Bill 32 is an omnibus bill. That means that it's a bill that makes changes to multiple pieces of legislation. In this case, it makes changes to the Labor Relations Code, the Employment Standards Code, and also legislation affecting people who work in the public service, who work in education, even people who work as police officers. Bill 32 doesn't do, it's a piece of labor legislation, but doesn't do anything much for workers, but it does a lot of things to workers. And all of them are bad, almost exclusively. But first and foremost, this is a union busting piece of legislation. In defending this law, the UCP has said that when the Notley government was in power, that they made changes to our labor laws that tipped the balance in favor of workers and unions, and that they are, with this bill, that they're just correcting this unbalanced situation. But honestly, nothing could be further from the truth. The reality is that before the NDP got around to reforming the Labor Relations Code and the Employment Standards Code in 2018, almost everyone in the country who knew anything about labor law agreed that our laws under successive progressive conservative governments were the most worker unfriendly laws in the entire country. And I remember working with the NDP at the time as the president of the Federation of Labor, and the NDP's watchword was to move Alberta to the Canadian mainstream when it came to workplace rights. And that's what they did, and that's all they did. So basically, there was no, if there was an imbalance, it was fixed by this legislation. It brought us to the Canadian mainstream. But Bill 32 doesn't just send us back to the pre-NDP conservative status quo. It actually takes Alberta entirely out of the Canadian framework of labor law. And and basically has the effect, if passed, of making us look much more like a Republican American state in terms of the intervention of government and a limitation of workers' rights. So despite its title, and they have this Orwellian title saying it's the Rebalancing Alberta Workplaces Act, despite the title, the bill is really about tipping the balance of power even further in favor of employers and the UCP as a political entity itself. So it is self-serving legislation. It's about weakening labor, which they see as a threat to them. In the workplace, it drops the floor of protections, and we'll go into detail about some of those changes. So people, a lot of the rules and protections that you currently enjoy in the workplace, they will be watered down and eroded, and it weakens our position at the negotiating table. And perhaps most significantly, from the UCP's perspective, this is about weakening the power of unions and working people on the political stage. They want to rob us of the resources that we need to be effective speaking out for working people, both in the workplace and on the political stage. And finally, and I think this is really significant, it's clearly designed to undermine the trust and confidence that the public and workers have in unions as institutions. They want to make it look like we're hiding things from our members, that we're making decisions that are not supported by our members and that are not in the public interest. They just want to reinforce these very negative stereotypes about unions, none of which are true. But aside from being a deeply political piece of legislation itself, which is ironic because they say this is about getting unions out of politics, but this is a very political piece of legislation aimed at helping the UCP themselves. But this bill is also unconstitutional, and we'll hear how that is. It flies in the face of Canadian laws, traditions, jurisprudence, takes us outside of the Canadian mainstream. It makes us look, as I said, more like an American state, a Republican right-to-work American state than a Canadian province. But it's clear from our perspective that this bill is unconstitutional. It's an affront to freedoms that are guaranteed in the Charter of Rights and Freedoms, especially the freedom of expression and the freedom of association. And I'll just wrap up my introduction by saying that if and when this law comes into force, it will shake our unions and indeed Alberta civil society to the core. Unions will not be able to operate as they have in the past, and the political playing field will be dramatically tipped in favor of corporations on one hand, but especially in favor of the UCP. So, I'm going to say this now, but we'll probably hear it again and again from not just me, but from all labor leaders in Alberta. This is simply not a law that we can allow to stand. It's a threat to working people in terms of our wages and protections in the workplace. And it also represents an existential threat to our institutions, unions, the broader labor movement, and it's a threat to democracy itself. So for that reason, I say that this is something that we can't simply learn to make peace with or find workarounds. It's something that we have to see as a line in the sand and something that we have to oppose with every fiber of our being.
Okay, thank you so much for that introduction. So before Leanne starts in, I just want to remind people, make sure you put in your questions in the Q&A, and you can put any questions there as we're going along. You don't have to wait to the end, although I'm sure you might have questions after the comments anyways. So now let's have Leanne take it.
Okay. Hi there. Welcome. I'm not a fan of talking on video. So you guys are very special that you get me doing this for you. And it's really the construct of these COVID times. And frankly, the whole situation that we find ourselves in with the virus, I think makes it interesting that this legislation is coming in, because to a large degree, it sort of surprises me that the government would go through at this time with these policy changes when they are still at a point where they're trying to convince workers to go back to work, that it's safe to work, that essential workers should work in conditions even if they're nervous about their safety, and to attack unions or to attack workers and their representatives, their trade unions at this time. It seems to me to be counterintuitive to an agenda of making us all get safely back to work. But as it is on the table. So this piece of legislation, Bill 32, is called, Restoring Balance in Alberta's Workplaces Act 2020. And so what I would say to you, my legal analysis is it doesn't restore any balance anywhere. It tips the balance that had existed in favor of employers pretty much on every single change. It does make changes to the Employment Standards Code. I'm not going to talk about those changes today. We're going to focus on the topics that Gil talked about in his opening. But it makes at least 33 changes to the labor relations laws that had existed up until it will get passed. And it does make at least 10 changes to the Employment Standards Code. So it's a significant number of changes. It's set out in about 82 pages, and it's dense. It's difficult to just read the new bill and go, oh, I understand the changes, here they are. You have to go back to the old code and flip back and forth. And you also have to often have a considerable understanding of the history of those provisions and how they've been interpreted before you can really understand what the government's getting at, which makes it really difficult for ordinary citizens to read it and understand what it means. But it's not impossible. What I would say is, if you want to read it, make sure you give it more than one go through before you say, oh, I get it. It's not quite that simple. A whole bunch of changes in this that are important. Frankly, every single change is important to, in my opinion, tip the balance away from unions and workers and towards employers. But given the time that we have today and the density and the difficulty in understanding these changes, I'm going to focus on some of the most important ones, the ones that go to the principles that Gil talked about. I'm going to start by saying there are significant attacks on the internal affairs of trade unions and their members, and I will come back to them in just a moment. I also want to talk a little bit about the changes to the act that both affect certification and the ability for union members to look to either decertify or get a new trade union in an open period, which are significant. And if we get a bit of time at the end of that, I will talk about picketing. Now, that is not to say that all the other provisions aren't important. It's just that the time we have really makes it hard to spend time on a lot more, but I'm happy to answer questions on all of the changes. So probably the most fundamentally important part of this change is addition to the law of some new things. One is trade unions are going to be required as soon as possible after the end of their fiscal year end to, and it says, provide to each member in accordance with the regulations a copy of their financial statement, which follows the requirements of the regulation and any information prescribed by the regulations. And so while that seems small, okay, trade unions already invite their union members, most trade unions I'm aware of in Alberta, to come into the office to review the fiscal information anytime they want. Most unions talk about their financial situation and pitch union meeting after their audit. Trade unions don't normally like to let that information go out the door in the hands of people, because then there's a very good chance it will go into the hands of an employer or a competitor union, and that will impact negatively on the union's bargaining strength and ability to take bargaining positions. And so the confidential information that the union holds dear the government is saying to the union, no, you don't get to decide that that's confidential. The union members who control the union don't get to decide that's confidential, that union members can see it, they can review it, they can spend as much time as they want at the union office looking at it, but they aren't to take it out into the public. The government's decided it goes out into the public, where as I say, the union member might leave it on their desk, management might see it, who knows. The bigger the union, the less likely that documents that go out the door with them are going out the door with members will stay confidential, despite the good intentions of the members to keep them that way. We'll say, oh, but we're not requiring it to be filed in a public registry, and that's true. But the fact is that they could add that in at any time. But most important, as I say, they're telling the union and its members how to deal with that confidential information. Within that, perhaps the far more important piece is the new provision, which is going to be called 26.1. And you're going to hear about this everywhere all the time. They call this the opt-in provision. And so this was in the union members, that they didn't get a say in how the union would spend their dues. And dues being union dues assessments, and initiation fees that they pay. Those are the three items that the government is legislating about, and I'm just going to call them union dues. So apparently someone, and I don't know, we can't determine how many, maybe 10, maybe 100 of the thousands and thousands of union members in the province told the UCP that they didn't get a say in how their dues were spent, and they didn't like that. So what section 26.1 requires now is for every trade union in Alberta is going to have to create what I call two baskets. It's the only way I can keep this straight. So you have basket A, which is section 26.1A, and then basket B. So I use A and B to kind of match the sections. Basket A is how much money am I planning to spend as a trade union on what they call political and other activities, as made clear what that includes. The other activities or other causes are general social causes or issues, charities or non-government organizations, organizations or groups affiliated with or supportive of a political party, and any activities prescribed by regulation. So this is money that the union dues might be used to support an event to raise money for charity, or might directly be given to a charity itself. It's money that you might spend on the Federation of Labor. I'm pretty sure that organizations or groups affiliated with or supported with a political party is meant to include at least the Alberta Federation of Labor, might well include other groups like the Canadian Labour Congress or others. Charities or non-government organizations, again, if we're supportive of, say, Alberta Labour History Institute, that may well get included. We'll see by the regulations. So that's all that piece, and they call it political, but it's much broader. It includes the charitable work of unions in Alberta. That's a very significant piece of work. And then basket B is the money spent from the dues for representation and collective bargaining, and anything else under the code, like certification or other applications under the labor code, plus anything that doesn't fit into basket A. So you've got A, it's political and other causes. B is representation and other trade union activities, is how I first sees them. Once the union, so if I have $100 of union dues I pay in a year, and the union says, well, $40 worth of that is going to go to those political and other causes, and $60 is going to go to representation, then the act requires that the union member be given an election. It has to be a written form where they would then elect to say, yes, I will allow the employer to deduct, I will allow the union to receive that basket A part of my dues. I agree the union can have my $40. I have to give the union my $60 because that's the dues for regular activities. And so if I decide as a union member, I don't want to support the other political and other causes, then the employer will only deduct from my paycheck $60, or that part of my dues that are allocated to basket B. If there's no election, it's assumed I elect to not support the basket A, and only basket B matters will be, or amounts will be deducted. The union can do this in a dollar amount, like my example, $40, $60, or they could say 40% 60%. Sometimes union dues are not consistent. Some unions, many unions work on a system where you pay a flat amount of annual dues or monthly dues, and then you pay a certain amount of dues based on your hours of work. Construction is a great example. Entertainment industry is another great example where the dues fluctuate depending on how much you work, and people might work quite a lot one month and quite a lot less another. So that's why proportions might be easier for a union to determine. Now, no other organization in Alberta is told by the government how to spend their revenue. No other organization percentages of how their revenue will be divided up between various activities and require the permission of their members or their shareholders or anyone on how to divide up and spend that money. The government gets elected and the citizens don't get to say, I'm only paying 60% of my taxes on the core activities. I'm not going to pay 40% of my taxes on those activities that I think are politically related to the UCP agenda versus the NDP agenda versus the Liberal agenda. We don't have this concept in any other part of our governance in Alberta or in, frankly, anywhere in Canada. And so it's a significant intrusion into the way unions operate. And frankly, I would say, in my opinion, it's unconstitutional. Unions are created by union members coming together to join together through the freedom of association that has been recognized under the Charter of Rights and Freedoms to be a right that's part of our democracy. It's a charter right. Unions and their members together also often are exercising freedom of speech when they do things, including their political activities are often about freedom of speech. They want to bring a campaign to say, we think that there should be an improvement to health and safety in Alberta. We're concerned about that. That's clearly freedom of speech and an important matter to the members of their union and to really, frankly, all unions and all workers in Alberta. Health and safety is always a concern. So this intrusion is significant. Now, I could go on for another half hour telling you all the details. I'm sure people will have questions about how it all works. But what I would say at this stage is what's important for you, everyone to understand is I hope that unions will fight it. But if you don't fight it, the UCP cannot make this law. And until people challenge the law, it's going to be on the books. So it's important that we be aware of it and that we start talking about what it means for us. Certification changes are, the UCP already took away automatic certification if 65% of the people wanted the union, and now there's always has to be a vote. But they have also made some changes to make it even harder to get certification. They've taken in all the timelines in the code. It used to be a certification file had to open and close within 3 weeks, 21 days, which really prevented a lot of unfair labor practices from actually happening anymore. There wasn't time. Now it's 6 months. The file has to close in 6 months. So those employers who want to discourage union members through unfair labor practices have all the time they need to do that. But perhaps even more importantly is certification. Under the current statute and has decided by the courts and the labor board previously, every 2 years in a collective agreement that's 2 years or more, every 2 years and every third or fourth or fifth year in a collective agreement, in the last 2 months, employees can seek to be organized by a new union. They can be liberated by for example, a more traditional union from a CLAC bargaining unit, for example, or from, they can change to a different union, and that is seen as a way of union members to pick who they want to associate with, and that when they want one another gives them that opportunity. And in fact, that is one of the reasons why we don't need this 26.1. If the union members are unhappy with how their union is allocating their funds, they can just get a new union they like better. That provision has that whole line of authority, that whole determination by the board has been changed, and they're specifically now going to allow a union and it's an employer to make a collective agreement before the open period opens up And then if it's voted on by the members, it closes the open period. So those members can no longer then go and seek to be certified by a competing union that they might like better. It means that unions who are more friendly to the employer, like for example, I'm going to say CLAC, now that's my opinion at least, can use that to block organizing efforts by more traditional or independent unions, such as the building trades. And so that, despite the fact that had been settled law in Alberta, that's not allowed in any part of the rest of Canada, it's certainly not in the mainstream of Canadian law. That is now going to be allowed under this new law. Again, I believe that's unconstitutional. Those rights of employees to make that choice once in a while, at the end of their collective agreement or in the second and further years of a longer term collective agreement, have been seen as fundamental to their freedom of association. So we'll have to look at the impact of that. I wanted to talk briefly about the changes to picketing because they're also quite dramatic and they're some particularly important. You've probably all heard about Bill 1. There was a big protest about Bill 1 this weekend at the legislature. There's already a challenge to Bill 1 brought by one of the unions, AUP, I believe, has brought that. I'm not sure if other unions will be joining in. But Bill 1 was brought in to allegedly help to quell protests against essential infrastructure. Is changed by this new statute. And it is changed to say that obstructing, I'm going to read this, obstructing or impeding a person who wishes to cross a picket line from crossing the picket line is a wrongful act. Now that might seem simple, but generally speaking, picket lines walk across in front of a car, might walk across in front of people who are walking across the line. And while we cannot and have never been allowed to totally blockade the entrance and exit from an employer's location, that's been always found to be going too far and against the regular laws. The ability to stop people long enough to get their attention, to show them that we have something we want to talk to them about, to convey our message that there is a strike here or a lockout, that employees have concerns, that they want the public or the customers or the suppliers to the business to be aware of them. That has been allowed to occur and not been seen as a wrongful act. Under Bill 1, if you commit a wrongful act on a piece of infrastructure, you then can be charged. And this minimum fine, no matter how lightly your wrongful act was, how little, is $1,000 each time. And so one of the pieces of infrastructure that Bill 1 covers is highways, sidewalks, public squares, any part of the places where an individual might stand that isn't private property. In Alberta. And so it's quite interesting when you tie these two together that it gives them an ammunition. And so picket lines will potentially be significantly impacted. And again, I believe that takes us outside of the charter. The second piece about picketing is that picketing there's an attempt in this bill to restrict your picketing only to the place where you actually work. Is an attempt to restrict you from picketing the head office of the company, or if they've moved their work over to another warehouse, to picket over at their warehouse. There's a limited ability to apply for permission from the labor board to picket at a warehouse if they've moved the work there. But it purports to say you can't picket for a labor dispute anywhere else. You couldn't go picket at the legislature or at the labor board. The Supreme Court of Canada has already said that's not right, that our constitution, our charter, the freedom of expression allows you to go and secondary picket as long as you do it peacefully and within the law. But this statute purports to override that. And again, I think it's unconstitutional. Now, I could keep talking all day because those of you who know me well know that I never shut up. But I think that that is the time allocated for me. And those are the particular parts I wanted to especially highlight in Bill 32. Pretty much every provision takes a right away from workers, a right away from unions, and gives a right to employers. I would also emphasize that a good employer, an employer with a reasonable relationship with their union, despite the fact they might fight about a grievance from time to time or go to arbitration to resolve an issue, one that has a reasonable relationship, there's virtually nothing helpful to that employer in Bill 32. It doesn't need, good employers don't need Bill 32. This bill is designed to allow those employers who operate in the fringes of the law to have more flexibility to operate in those fringes, in my opinion. Thank you.
Thank you so much for that, Leanne. So I'm just going to say just a couple of things because we do have a number of questions to get to, and I want to dedicate as much time as that. Really, this bill is an insult. It's an insult to unionized workers. It's an insult to all workers, but it's definitely an insult to unionized workers because we have so many checks and balances within our system, so many ways that unionized workers can participate in the democratic processes within their union, to then say that that is not enough, it's not sufficient, that we need government to intervene as well. And essentially for people to be able to say, well, my team didn't win, so I'm going to take some of my money back with me and not let them have it. And it's really part of the government's overall economic strategy that includes low corporate taxes, that includes lower wages, poor working conditions, weak regulatory and environmental standards, that a lot of these bills work in unison together to make any resistance to their change more difficult and to really take power away from workers and just the average people. So that being said, I think that we should really just try to get into these questions because we're pushing on 30 questions. So the first question that we had was, why doesn't the federal government intervene in either Bill 1 or in Bill 32? And is there like a jurisdiction or a role for them in this?
I guess that's for me. It's not the role of the federal government to police the provincial legislation. Having said that, if a charter case is brought forward, a challenge to the law under the Charter of Rights and Freedoms, that's what a charter case is for those of you maybe less familiar with the lingo, government has a right to join in if they want to, because the charter is a federal law. In addition, it's because some of the decisions of the Supreme Court of Canada are affected by these changes. It might be that the federal government does want to play a role in watching what happens or get involved, but they don't have to.
Yeah, I would just add two things. The first is that even though the bill has not been passed, it is not law yet, unions from across the province and indeed across the country have been watching. We all understand that if this bill becomes law, it will undermine the rights of working people, both union and non-union, in fundamental ways that we're not willing to accept. So the labor movement has basically already made the decision that that this is a law that will be challenged. We'll pursue those challenges. We will be on our way to the Supreme Court. And one of the reasons that this is getting so much interest outside of Alberta, and this leads to my second point, is that we believe that Jason Kenney and the UCP are not just trying to transform Alberta in the image of a Republican American state. In fact, they want to use this labor law in this province as a beachhead for changes that would be implemented by other conservative governments across the country. And make no mistake, the Doug Fords and who's the Premier of Ontario and the conservative premiers in places like Saskatchewan and New Brunswick, they're watching. And if Jason Kenney is able to get away with this here in Alberta, it won't be very long before we start seeing these kind of attacks on unions and working people in other provinces. And for that reason, that's why the labor movement is already gearing up for a big legal fight.
So a couple of the other questions deal with the RAND formula. So this might be in Leanne's court. Can you talk about how the RAND formula might be related or not related to this, or how it might be cut? Like there might be some help there, or maybe not.
Well, what I would say is that the provisions of the code that impacted the RAND formula and the decision of the Labor Board that the RAND formula is a minimum hasn't been specifically changed. The attack is more on how unions will spend their dues rather than whether or not they can collect them. And not how they will spend it, sorry, how much of the planned dues will be collected depending on basket A or basket B.
If I may as well, like for those who are not familiar with the term RAND formula, maybe a little bit of a history lesson and definition. The RAND formula is actually one of the pillars of Canadian labor relations, and it's one of the things that really sets Canada apart from the United States in terms of the way we organize our system of labor relations. And basically, the RAND formula refers to a decision made by former Chief Justice of the Supreme Court, Ivan Rand, in the 40s. And so it's a long-standing tradition, and basically it grew out of a period of labor unrest, in particular some big auto strikes in Ontario. And the question at the time, one of the questions that was being addressed was, should everyone who is covered by a collective agreement be required to pay the dues to the union? That dues should be optional, and the unions wanted what they called union security, which is, like if you get the benefit of a collective agreement, you should pay for it. You're getting the higher wages, the better benefits, you should, and that's valuable. So you should be paid for that. So there was a very heated strike. It was lasting for a very long time, and so the federal government of the day called in Justice Ivan Rand to basically intervene, to rule on the situation, and he came up with this balance. And he said, workers don't have to join a union, but they do have to pay dues to the union that negotiated the contract that they benefited from. It's called the RAND formula. And basically, it's the law of the land in every province, including Alberta. We used to be an outlier in that regard. The New Democrats brought the RAND formula into legislation when they were in power. But basically, it says that if you benefit, you got to pay. Otherwise, you're a free rider. And that's been one of the cornerstones of Canadian labor law. It's like, there should be no free riders. It's not fair. The Supreme Court has, since that time, has elaborated on their rulings and basically said that unions not only have the right to have dues collected to pay for the services they provide to their members, but also that the union should have some wide discretion in terms of how they use that money, not just for what the UCP is trying to do here is define core services, and they define them very narrowly, and then create this other basket of services which are non-core. And they're saying that like the RAND formula should only apply to the core services. Everything else should be up for a vote all the time, completely ignoring our internal systems for democracy. But this also flies in the face of Supreme Court jurisprudence, which basically says the Supreme Court has recognized in case after case, especially recently, that the job of a union goes beyond negotiating a particular contract or administering a contract, that in fact unions can't really do their jobs on behalf of the workers they represent if they are not active on the political stage, if that's what they choose, right? Because a lot of the things that we advocate for in the labor movement are actually not, they're things that affect our workplaces, but they're based in law, right? So WCB, government policy on spending, all these things are political. So as one of our presidents at the AFL always says, Heather Smith from the United Nurses, she says, we could ignore politics, but politics won't ignore us. And so, this notion that unions shouldn't be political is just nuts. I mean, like if we were to agree to that, we'd be basically tying one hand behind our back all the time. Of course, that's exactly what the UCP wants, and that's what they're trying to enforce with this legislation. But it is not in keeping with Canadian traditions in terms of law, and it's certainly not in the best interests of working people. They join unions for the strength that they provide, and this is the opposite. It undermines the strength that people join unions for.
Okay, so some of the questions are asking about what is the consequence of not adhering to this opt-in, and that if there are unions that do adhere to the opt-in, does that hurt any legal challenge?
Well, they put, okay, so there's always a consequence when you don't comply with the law. So we can start with that. And there are specific penalties set out in Bill 32, and they're quite significant. You would, a challenge that the law is not being followed is brought to the labor board. It is not clear who can do that. Certainly an employee who's a member of the union would be someone affected, but they talk about the party to the dispute. So it appears clear that an employer could bring that dispute to the labor board if they wanted to, and then presumably get all the information about all the expenses and the proportions and every little chit and receipt that we ever had. The privacy issues are stunning. But it also, who knows, maybe even another, like the government or the attorney general or another union could bring this. Who knows? It's not clear at all at this stage. Normally, a party to a dispute has to be someone impacted by the activity. And so the labor board can require unions to produce information. They can adjust, the labor board can hear the case and then adjust those proportions or amounts of dues in basket A and basket B. They can say, union, you put the wrong stuff in the wrong baskets, which is kind of shocking, right? The labor board's going to determine how the proportions that the union spends on various things. And they can suggest the collection of dues has been in contravention and it has to cease. So it's against the law for an employer to deduct dues without an election. It's against the law for a union to receive dues without the election for the part A part of the basket. So they could say that that law has been broken. They can order that the money be repaid to the members who shouldn't have had it deducted. And they can suspend the trade union's ability to collect union dues from employers or employees. So they can suspend the union's right to take any dues if they think it's egregious enough. So there's a punishment element there too. So that whole piece is quite significant. Sorry, there was another part of this question, Susan, remind me.
Oh, if a union does adhere to this, does that affect a potential court challenge from other unions?
And the answer to that is no, neither the union who's following the law nor other unions are prevented. You know, the is very much applicable to a charter challenge. If you say, gee, we're not going to rack up penalties for breaking this law, but we're going to challenge it on the basis that it's unconstitutional, you can certainly do that. The other thing is, if a union is charged or brought to the labor board for breaking the law, you can raise the charter application as a defense. Now, it's a little bit more complicated than that. The labor board can't actually strike out that law. It can only say the law violates the charter and we're not going to apply it. For trade unions to actually strike out the law, they have to go to court, but you could do both. And a decision from a labor board saying the law is unconstitutional would, in my opinion, be quite persuasive to a court hearing it later. So that's one way to maybe get this before a decision maker faster.
Yeah, I would just add that, clearly the UCP intends to impose serious consequences on unions if they don't comply. And as Leanne has suggested, the LRB will now, the Labor Relations Board will now have the power to suspend all dues collection if they find that a union is not in compliance with any part of this law. But I would also suggest that there are serious costs. As Leanne has explained, basically what the government is doing here is forcing unions to put all their spending into one of two categories: the core functions and then everything else. And that category of everything else, depending how the government defines it, and once again, it's the government that's going to define what fits into the other bucket. And they put the label political on it, political and social issues, to leave a bad taste in people's mouths, because people don't like, and I get it, people don't like politicians and political action. But this bucket includes things like charities, it includes things like member education, it includes things like lobbying, which of course unions do. Imagine if they told corporations that they couldn't lobby, like the Canadian Association of Petroleum Producers couldn't lobby on issues related to oil and gas if they didn't get member organization shareholders. That's crazy. But in terms of the cost of compliance, if we comply, we have to go through this election process in order to get the green light to use members' money for things that go into the second bucket. We, the unions, the onus is on us to go out and run the elections, get approval in a process that is yet to be determined. It's not actually in the act. The government will decide how these elections run through regulation, which is made behind closed doors by the politicians involved in the UCP cabinet. But if we don't follow the letter of that, if we follow the letter of that law, we get these elections, right? We get a list of people who have agreed to pay for the second bucket, the political bucket. And then we have to provide not just the numbers, the results of that election to the employer. We actually have to provide the names and the contact information of every single employee who has agreed to support the union's political action. And you know, first of all, it's going to be hard to get people to agree. You know, so you're never going to get 100%. So we're already losing some money there. But this list that we create of people who, you know, elect to support union political action, this is going to be a target list for the employer. It's a list of people who are troublemakers, who are you know, the ones who are willing to rock the boat. And so, you know, there's some concerns about, like, you know, what are they going to do with that list, right? I mean, will they use it to, you know, target people for reprisals? Will people suffer in terms of promotions and shifts, you know, that kind of thing? And even more so, I mean, it could be used as a list for the purposes of decertification. So, you know, by complying with the law, we may actually be slitting our own throats down the road. So, you know, like, so yes, there's a cost in not complying, because we could have our dues suspended, but there's also a big cost in complying.
If I could just, I mean, and I agree with everything Gil said. There's just a couple things I think I should clarify. The election is intended, as this is written, to be I, an individual, make my own decision about whether or not I'm going to pay the basket A political things or not. And so I believe that what they will contemplate is there's a form that I fill out and sign and give to my union. Not that I would be an election of people where I would go to a union election. And so the words become confusing too. And so, yes, there could be a huge cost in just getting those if the union is big and members don't normally come to the union or reply to union emails. Some unions might find it very easy to get everyone to just sign when you're done. And Gil's quite right. Once a person makes an election, then the union transmits their name to the employer, and then the employer adjusts the payroll to deduct from that person's dues 100% of the dues. The person can also change their election. They could decide in a month they're mad at the union and revoke their election. And then the union has to tell the employer, this person has revoked their election, change their payroll deduction again. Now, an individual can apparently do that as often as they want, which is interesting in and of itself. But it does certainly create this problem with identifying people who believe that certain activities should happen and not, which is quite difficult. So yeah, there's a good chance that the first cases will be unions who aren't fully complying with this and are being brought to the labor board, and the charter challenges start there. Who knows what the strategy will be.
Okay, so there's just two other questions I think we have time for. And so one, there's a couple of questions that people have about how the bill affects non-unionized workers. And so perhaps, Leanne, could you do a really high level overview of that? And then the last question is for Gil, which is, what do we do now? What can workers and unions do now? And then maybe we can look at wrapping it up. And then we can talk about what the follow-up will be for all the questions that have been posted but yet answered.
Okay, so there are some changes to employment standards, and as I said, I'm not outlining those here. They are not as horrible as they could have been, but they are not gentle, and they again just take away things from non-union work employees for no good reason, for no, in my opinion, for no real balance. And we'll get to those, I'm sure, in another matter. But for this bill, for the labor code for non-union workers, it means that non-union workers, it changes the certification provisions. It's probably the biggest one. If I'm going in as the union to certify a non-union group, it used to be that under the NDP law, it went quite fast. And so that limited the number of unfair labor practices, the pressure that came from employers. It really did make a difference to the ability to organize. And, you know, before that, there was also the ability to organize and have no vote, which even made it easier. With these changes for those non-union folks, we're back to the times before that, before the 2018 amendments, where a union organizing campaign may well include a whole lot of unfair labor practices. You only need to think of any number of, think about the casinos, think about Brooks, think about all of those campaigns to think about the level of unfair labor practices and pressures that put on non-union people who are trying to organize in a union. The closing of the open period very much affects the ability of people to change unions, which is also kind of related to that. And those are probably the two biggest impacts on the non-union workers in labor code part.
Okay, and Gil, would you like to comment on what we can do now as individuals, unionized workers, and unions?
Yeah, before I get to that, I just want to add, because I didn't hear Leanne mention the issue of overtime. You know, when it comes to non-union workers, one of the, as I said at the outset, Bill 32 amends, it's an omnibus bill and amends a number of pieces of legislation, including the Employment Standards Code, which provides the basic floor of rights for all workers, including non-union workers. And it does all sorts of awful stuff. But the one that I think is particularly egregious is that it gives employers new tools to avoid paying overtime pay for overtime work. It used to be that employers could enter into what are called overtime agreements with their workers for periods of up to 12 weeks, in which the employer and the worker would agree to average their hours over that period. And so if they worked a few extra hours one day, it would be offset by a day where they might have the day off or work shorter hours. Now, under this new legislation, the length of these agreements will be indefinite, so they can average them over much longer periods of time. And they're no longer really agreements. They still call them employment agreements, but kind of Orwellian, because it actually says in the legislation that the agreement can be imposed, which is like not an agreement anymore, right? So basically, for employers who are using this new tool that the UCP is handing, that people working under those so-called agreements will work many overtime days and weeks without ever getting overtime pay. So that's a big deal. So the final question is, what are we going to do about it? Well, as a labor movement, as you can imagine, we've been meeting and talking, very extensively since the bill was tabled last week. In fact, some of our conversations started before that because we knew it was coming. So we've done a number of things. The first thing is that the unions affiliated with the Federation of Labor have launched an aggressive digital campaign called the Defend Worker Rights Campaign, which is targeted, to make the point that this is a political attack on the part of the UCP to silence a group that stands up to them. And that's actually I think that's a key point. Why are they targeting us? It's because we push back. That's what we do. And there's an American economist named Paul Krugman. He's a Nobel Prize winner, and he wrote a few years ago a column which I think is very appropriate for our situation today. And in that column, he basically said that the labor movement is the only effective counterbalance to the power of corporations and the politicians that serve them. And that's true. Individual workers don't have a lot of power themselves, but when they come together, they have the resources and the wherewithal to push back. And that collective action taken through unions is exactly what the UCP is going after. They know that we are a threat to them. They know that we will push back against their agenda of privatization, cutbacks, polarization, which I think is new. You know, all this pot stirring about separation. We don't want Alberta to be turned into a clone of Mississippi or Alabama or another, you know, American right to work state. And we'll fight tooth and nail for that. And they know that, and that's, they want to rob us of the resources to effectively discharge that job of being a counterbalance to the power of the wealthy. That's what this is really about. So we've launched digital campaign, defend workers' rights, to talk about what we do and why we're being targeted. If you haven't done so already, please, you know, go to www.defendworkerrights.ca, sign up, and we'll give you information about the campaign. But in addition to the digital campaign, which is still ramping up, by the way, we have some really good videos on the way. But in addition to the digital campaign, our unions are meeting right now to talk about legal challenges. We're having a big summit on a legal challenge in the next couple of days. So it's not a question of if we'll challenge the law, it's when we will. And it'll be a national effort, not just an Alberta effort. And then the final thing is, and I hate to do this, but we are having meetings about real world action. So taking the fight from the digital realm, which frankly is sort of the only thing that we can do now because we're still in the midst of a pandemic. But we are having conversations about taking the fight from the digital realm and bringing it out into the real world. In fact, just this morning, our executive council endorsed a plan, but we're still fleshing that plan out, and we're shopping it around to a few of the big non-affiliated unions to make sure that we can present a united front. And so, because we haven't had those conversations yet, I'm not quite at liberty to share all the details. All I can say is just stay tuned. We're not going to, this bill may, you know, the UCP may be able to use the majority around this bill through the legislature, but it's not going to end there. And the final thing I'll say is that, you know, it's really important that people step back and connect the dots, because this is not just about Bill 32. We have to, you know, take the wide view and see and understand what the UCP has been doing since they won election a little bit more than a year ago. You know, they have an agenda that is not a conservative agenda. You know, they call themselves a conservative party, but they're actually a very radical party. They want to make radical changes to our province and to our society, government in our society. They want to limit the, you know, the power of ordinary people in favor of the power of the wealthy. You connect Bill 32 to Bill 30, which is their bill to privatize healthcare, and to Bill 1, which wants to, you know, criminalize protest. Put all these things together, and this is a very, very radical agenda that I'm pretty sure most Albertans, even those who voted for the UCP, this is not something they support. And so, you know, when we as a labor movement say we're going to fight, it's not just against Bill 32. We're going to fight against this whole agenda, you know, for the sake of, you know, of our members, for the sake of our institutions, but most importantly for the sake of our province. And so, you know, I just encourage all of you to sign up for Defend Worker Rights campaign, or sign up for the AFL newsletter, and we'll keep you abreast and informed about what we're doing, because like we can't do this alone. It goes back to the power of, I mean, unions are people, right? And our real strength comes from our members. So the more people who sign up, the more effective we will be in terms of our efforts to fight back against this law and the broader UCP agenda. So thanks for joining us tonight.
Okay, with that, I just want to thank you both, Gil and Leanne. The conversation has been fantastic. We have a number of questions that we just could not get to tonight. So there will be a follow-up for participants where perhaps we can get Leanne and Gil to answer these questions, and we can send some more information out. We'll also make available the video as this was all recorded. So if there's anything that you missed, don't worry, we can go back. But once again, thank you everyone for coming out, and thank you for our participants.
Thanks, everyone.
With that, I hope everyone has a great night.